Hi, this is Ty Hadarali. I'm a plaintiff's lawyer. We concentrate in employment law in New Jersey and New York. So I'd like to talk to you about some changes that have coming out of the Department of Labor. So when President Trump was president, he modified the rule on how to classify independent contractors. And previously, the test to classify independent contractors was a 6-factor test. He parted down to simply 2 factors. The control exerted by the employer and the what was called the profit and loss attributable to the independent contractor. And basically the ramifications, the result of the modification made by former President Trump, was to make it easier for employers to classify people as independent contractors. And what does that do? Well, that strips you of your right to numerous benefits and protections under the law, numerous statutory protections to be free from discrimination and harassment and whistleblower retaliation, and also overtime protections. So it was a pretty significant situation facing employers. Well, the good news is that has now been reversed. The Department of Labor reversed that bill, that action passed by President Trump, and has gone back to what's called the economic reality test, which is taking into consideration 6 factors to determine whether someone should be classified as an independent contractor as opposed to an employee. And many people who are thrilled about this decision by the Department of Labor contend that this modification brings the Fair Labor Standards Act more into line, or brings the interpretation more into line with the Fair Labor Standards Act. And so this is a big win for employees out there in getting the protections that are deserving to them under the Fair Labor Standards Act. This is Ty Hadarali. Be well and be safe.